This is Barry Zalma, Zalma on Insurance. I'm an attorney who's retired from the practice of law and now spend my time as an insurance claims consultant and expert witness. Twice a month, I publish Zalma's Insurance Fraud Letter, this one being Volume 25, Issue Number 10, available on May 15, 2021. It contains multiple articles about insurance fraud and various information about convictions of people who have committed insurance fraud and were convicted by courts of general jurisdiction. The lead article in today's edition is one entitled EUO is a Condition Precedent. People who commit insurance fraud tend to run from serious insurers who deny claims for fraud, misrepresentation, concealment, or failure to fulfill conditions precedent. For example, when State Farm filed an unopposed motion for summary judgment against defendants All-Med Merchandise and Trading, Inc., and others, probably because the defendants knew they had no case, and placed their efforts to collect from fraud by going against insurers who would rather pay than fight. The case was titled State Farm versus Advantage Medical Innovations Incorporated and others, which was decided on April 21, 2021 by the Supreme Court of New York on April 21, 2021. The trial court was asked to rule on State Farm's motion for summary judgment, claiming fraud by the insured. State Farm sought a declaration that it had no duty to provide coverage or make a payment of claims for no-fault benefits made by or on assignment of Peter S. Rosario, the insured party, Cheyenne Griffin, the driver, and Shrake Hoffman and Omar Osborne, passengers in the vehicle. The no-fault claims sought to be nullified arose out of a two-vehicle collision that occurred on October 28, 2018 on Pennsylvania and Stanley Avenues in Brooklyn, New York. State Farm's motion against All-Med Merchandise and Trading, HAR Orthopedics, and Sports Medicine PC, among others, was based on an intentional act, and that Griffin, Hoffman, and Osborne's injuries did not arise from the incident, that Hoffman failed to appear for his examination under oath, and that Griffin and Osborne failed to return subscribed copies of their examinations under oath. An intentional and staged collision caused in the furtherance of an insurance fraud scheme is not a covered accident under the policy of insurance. A no-fault insurer is not required to establish that the subject collision was the product of fraud, which would require proof of all elements of fraud, including scienter, evil intent, by clear and convincing evidence. Rather, a no-fault insurer must determine the facts elicited during an investigation which make up the founded belief that the alleged injury did not arise out of an insured incident. In support of the motion, plaintiffs submitted the examinations under oath transcripts of Cheyenne Griffin and Omar Osborne, as well as an affidavit of merit from Timothy Dacey, a claims specialist for Plaintiff State Farm Mutual Insurance Company. Griffin testified that the light at the intersection was green. She proceeded through the intersection and was almost fully through the intersection when another vehicle pulled out of a parking space and forcefully hit her vehicle's right bumper. Osborne was asked how he found his attorney, and he stated that the lawyer contacted him, picked him up, and told him that he had a lawyer. He guesses that the therapy people gave them his contact information. State Farm submitted the affidavit of claims specialist Timothy Dacey. He testified that the claimants began receiving tens of thousands of dollars worth of treatment from various medical providers. Dacey further averred that the claim's legitimacy was questioned since the insured was not in the vehicle at the time of the accident, and that the insured's policy was canceled 1 month after the accident due to non-payment. Additionally, the fact that the insured obtained new insurance with Geico and was subsequently involved in 2 additional losses, one on November 11, 2018, and one on November 25, 2018, involving a friend driving the insured's vehicle. Lastly, the fact that none of the claimants alleged injuries at the scene of the accident and thereafter began undergoing significant treatment with a large number of medical providers also contributed to the plaintiff questioning the legitimacy of the claimant's representations. The court concluded that State Farm met its prima facie burden, establishing that there is a founded belief that the collision was intentionally caused, that the loss was not a covered event, and that the claimant's injuries did not arise from an insured incident as evident from inconsistency in the transcripts. Additionally, State Farm asserted that Hoffman failed to appear for his examination under oath, and Griffin and Osborne failed to subscribe the examinations under oath transcripts, violating conditions precedent to no-fault coverage. The failure of a person eligible for no-fault benefits to appear for a properly noticed EUO constitutes a breach of precedent, vitiating coverage. The injured party or the party's assignee, medical service provider, must then submit a proof of claim, or it will be precluded from offering any defenses at trial. As to Griffin and Osborne, who submitted to their EUOs, although they appeared, they failed to subscribe and return the transcripts. The claimant's failure to subscribe and return the transcripts of their examinations under oath violated a condition precedent to coverage and warranted denial of the claims, and therefore the court ruled that State Farm's summary judgment motion was granted. The decision from New York is an example of the need for insurers faced with a potential fraudulent claim to refuse to pay. It will find that fraud perpetrators are unwilling to fight an honest attempt to defeat a claim that was fraudulent, since it was more profitable to assert fraudulent claims against insurers who are unwilling or unable to fight a fraudulent claim. Since the fraud in this case was obvious, State Farm was obligated to fight. It did so and avoided a fraudulent claim. Of course, it had to spend the money for lawyers and investigators to do so, and the court just granted their motion rather than what it should have done was to refer the defendants to the local prosecutor for criminal prosecution of attempted insurance fraud. In addition, the May 15, 2021 edition includes an article entitled "Lie on an Application for Life Insurance Voids Coverage," which supported the rescission of a life insurance policy where death occurred before the expiration of the 2-year policy provision preventing disputes of coverage. The insurer discovered that both the policy owner and the decedent lied on the application with regard to, among other things, the decedent's drug use, and the rescission was affirmed by the United States District Court, Eastern District of Louisiana, on May 4, 2021. The case teaches that although rescission is an ancient equitable remedy. It exists so that no one may profit from fraud or misrepresentation or concealment of material facts in an application for insurance. In that case, the insured and the decedent lied on the application for insurance, and it was established that the insurer would never have issued a policy on the life of the decedent because of his drug use and mental disorders. Equity, fairness, required the court to affirm the rescission of the policy. This May 15 issue also includes an article on insurance fraud statutes and explains why and how those statutes work to protect insurers against insurance fraud and make a crime out of attempted insurance fraud. It also reports on convictions reported by the Coalition Against Insurance Fraud and an article about ethics and the public insurance adjuster. Some public insurance adjusters, acting alone or with the assistance of unscrupulous lawyers, violate the standards set by the National Association of Public Insurance Adjusters and the Covenant of Good Faith and Fair Dealing. For example, in a case called U.S. v. SATA, a 1999 decision of the Third Circuit Court of Appeal, the U.S. presented evidence at trial that showed in 1990 the appellants contracted Ezra Rishi for help in an insurance fraud scheme. Rishti was a public insurance adjuster in New York City who had conspired with various clients in over 200 fraudulent insurance schemes in the past. Rishti agreed to assist Isaac in filing a fraudulent insurance claim and enlisted the help of Morris Beta, a former employee who by then owned his own business. In a not officially reported opinion, the California Court of Appeal dealt a serious blow to an attorney who filed an apparently malicious and unfounded lawsuit against Scottsdale Insurance Company. In that case, the Court of Appeal decided that the attorney must stand trial on an action from an insurer for malicious prosecution. Further detail is available in the article when you download the full text of Zalma's insurance fraud letter from my website, zalma.com. It also reports on health insurance fraud convictions, including where a person named Folashade Adoufe Horn was sentenced to prison for defrauding Medicaid out of hundreds of thousands of dollars. A case where AlXRX LLC agreed to pay $2.75 million to the United States to resolve allegations that it improperly dispensed controlled substances at a long-term care facility. An article about a manager of a hospice and home health company who was sentenced to prison for his role in a $150 million health care fraud scheme. An article about how a pharmacy owner pleaded guilty to a $6.5 million health care fraud scheme. A story about how a Missouri Attorney General obtained $300,000 settlement in a Medicaid fraud case. A story about an Alabama doctor sentenced for conspiracy to distribute a controlled substance. A story about a Dubuque care facility owner who agreed to repay federal Medicaid funds to resolve allegations concerning a COVID-19 screening procedure. A payment of $22 million by the University of Miami to settle claims involving medically unnecessary laboratory tests and fraudulent billing, and a story how Tykees McCrae of Iowa City, Iowa, was sentenced to prison for fraud, a story on how Holly Telford Lundahl was convicted in South Dakota of healthcare fraud and identity theft. In addition, there are articles about fraud convictions other than health insurance fraud, including how a former Madera insurance agent was convicted of felony grand theft, how a North Carolina man was sentenced to 63 months in prison for COVID-19 relief fraud schemes, and a story how a broker pleaded guilty to facilitating elder fraud in actions that cost more than $9.5 million in losses to consumers across the country. Then the fraud letter describes new books available to and for the help of fraud and insurance claims investigators, including how insurance fraud costs everyone, and books on insurance fraud written by me that are available from Amazon.com as both paperbacks and Kindle books. The link to the full Zalma's insurance fraud letter dated May 15, 2012 is available at Zalma.com and also at the blog posting at https://zalma.com/blog. If you found this video to be interesting or useful to you, please pass it on to your colleagues. It's free. And please also subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos and blog postings. Thank you for your attention.